Hi everyone, Michal is here, and our next session is with Yael Cabilly from Cabilly & Co. And we're going to talk about how to protect your brand on Walmart. Such an important topic, and I'm super excited to have Yael in here. Yael, I'm going to give you the stage.
Thank you. Thanks, Michal. Thank you for inviting me. Very excited. So maybe a quick background about us and what we do. The law firm was founded in 2016. We're a team today of 16 people, mostly focused on e-commerce law, and in particular platforms. So Walmart, Amazon, eBay, Etsy, and other platforms. We also represent Shopify sellers, so D2C sellers. And we do two main things: intellectual property on these platforms, meaning protecting your IP, but also protecting yourself from complaints from others. So that's one thing, intellectual property. And the other part of the firm handles mostly suspensions and removal of your items on Walmart or other platforms. We're proud to be ranked top 50 attorneys in the United States for trademarks. We're number 17. And we worked, I think, over the years with almost these days, I think almost 7,000 sellers worldwide on various platforms. So that's in a nutshell about us. The first topic I wanted to discuss is the Walmart brand portal, which started several months ago. So that's we all feel it was kind of imported from Amazon's brand registry. We feel it's pretty similar, and you know at least the process isn't so far from Amazon. What you do is you present your trademark. The trademark must be registered. So a trademark that is only pending, like we do on Amazon, won't be enough at this stage to get the Walmart brand portal to be accepted. And you also need a US trademark. So while on Amazon, a European trademark or a trademark on any platform that Amazon's present, it would be enough. Here on Walmart, you need to present at this stage a US trademark. We are sure that in the future, a very near future, and we hear from Walmart as well, by the way, that it's going to be expanded to additional countries. So that's that. What is the brand portal? Let's start with the most important question. It's basically a kind of internal platform within Walmart where you can handle the protection of your brand. So for example, you see someone jumping on your item and trying to sell the same thing, and it's actually a counterfeit product. It's not a real one. You can file a complaint, and then you will see it on the portal, and then you will see the stage of your complaint. So you will see when it's accepted, when it's rejected. You can see past complaints. So that's very easy, because before that, you could file a form and complain against someone, but then you don't know what happened to it. You're waiting to receive a response. There's no tracking. So this is much easier. And it's mostly easier and faster. Like these are the two main advantages. We think that in the future it will probably add additional features that are closed only to the brand portal owners. So that's in a nutshell. Like Amazon, Walmart as well does not help you remove unauthorized sellers. So let's say you're Tiffany, and you see sellers that you never authorized to sell on Walmart, and you want to remove them. You can file a trademark complaint, but it will be rejected if it's not a fake. Okay, if it's the same, if the seller is actually selling the real thing, that they bought, I don't know, from the distributor in Germany, and then they sell it in the US. If it's not counterfeit and it's the real product, they are protected under what we call the first sale doctrine. That's an American doctrine which says that once it was sold once, Tiffany has already received the payment for that sale. So after that first sale, they're allowed to resell the product, and the brand can't really prevent that. So, and these platforms, Walmart and eBay as well, and others, they like the competition. They like to have several sellers competing and kind of getting the as low as possible price for their customers. So Walmart, just like other platforms, does not remove unauthorized seller. That's not the way. And do not use the brand portal to remove them, because Walmart can take back your brand portal rights. So that's in a nutshell about that. Now I want to get to the most common IP mistakes that we see on the Walmart when it comes to, let's say, the average seller. Okay, as an average seller, I'm not talking about a seller that started yesterday. Let's even talk about a seller that started a year ago or a year and a half ago. One of the most common mistakes that we see is related to trademarks. So let's take a situation where the seller chooses a name. Okay, let's think of a brand. I called my brand Chapnik. Okay. And then after a while, I start manufacturing, let's say, I don't know, wallets under the brand Chapnik. I did not conduct any trademark search, but I did a Google search to make sure that it's okay. It's nobody took it. I even buy the domain name chapnik.com, and then I launch the listing and the brand, and the item appears on the Walmart. But then when I want to apply for the brand portal, it turns out that I want to apply for a trademark so that I can get the brand portal. And then at that stage, the lawyer tells me, sorry, it's already taken. Chapnik is already registered in relation to wallets or to something similar, not necessarily wallets. Or maybe it's not the word Chapnik that is registered, but Chapnok, okay, which is very, very similar, right? Just one letter of a difference. That's, I think, one of the most common mistakes. Many sellers actually do a search, but they do a search for the exact same name, and they don't realize that the trademark world is a little broader than that. So maybe Chapnik isn't registered, but Chapnok is taken. If that's the case, you won't get a trademark. And then when that happens, then Walmart rejects the brand portal because you don't have a registered brand and you have to rebrand. And I don't know how many of you have done that, but rebranding is a very, very big headache. So to prevent that, what we recommend is to conduct a search before you manufacture, before you even start using the brand. Maybe after that first Google search that you've done, ask your attorney to conduct a search. It's usually free. It's part of the cost for a trademark. So, for example, we included in the registration, and you can even do a search with many lawyers. It's the same. You can conduct a search, pay a certain price, and then they retract that later when you register the trademark. So basically, it doesn't cost you anything, and then it saves you the trouble of rebranding later. And going without a trademark, I can tell you that not only on the Walmart, but on any platform, and even if it's your own website, operating without a trademark does not make sense at all. For any kind of private label, what you have is your brand. It's probably your biggest asset. And I can tell you that down the road, and we've sold some Walmart businesses at Fortinet. I can tell you that down the road, nobody will buy your business if you have no trademark. Okay, forget about the brand portal. A trademark is essential for any seller on any platform, unless you do not have a brand. If you're a drop shipper, you don't need to register your brand. But other than that, it's crucial. And unfortunately, many sellers realize that only after they start having those problems. I can also add about that before the platforms started requiring a registered trademark. So before Amazon started with the Amazon brand registry, and before Walmart starts with the brand portal, the brand owners weren't really thinking about trademarks. They were only, there were registration here, registrations there. When those platforms started requiring that and telling the sellers, hey, if you don't think you're a brand and you don't have a trademark, we don't think you're a trademark. We won't protect your brand. When that happened, sellers started to understand they need it. And I think Amazon has done the work for Walmart sellers as well. And now they're more educated. They understand they need a trademark, but they don't conduct a search. Here you can see an example. Even before you go to an attorney, at least run a basic search. Maybe you will kill that brand yourself. Okay, so for example, if I have the brand Blendy, I would search for Blendy with a Y and Blendy with an I and Blend and Blendy, and we'll try to think of several alternatives. So of course, as attorneys, we do a different search, not that kind. But this, even without it, you can look at certain variations and see if the trademark is available. So that was about trademark. Michal, if you have any questions or comments, feel free to interrupt.
Yeah, I think it's so important because working with clients, we have those obstacles all the time with the trademark, especially what the biggest issues that brands coming to Walmart and they didn't register to the brand portal, and then they're coming to this issue that they're trying to optimize their pages, but somebody was coming before them and created their product page, and now they have no control, they have no way, so now they have to go to the brand portal and register. And sometimes it goes smoothly and sometimes there's issues. Like we have one client that even because his address on the documents for the trademark was not similar to his company address, that's a problem. So a lot of things like that, it's really important to do everything on the right time and correct, especially with the names and addresses, and protect yourself.
I think that with time, sellers will understand that it's not only about removing others, it's about protecting your own and preventing others from hijacking your brand. We've had cases before sellers knew about trademarks. We had terrible cases. We had a case where a seller that was already at, I think, around $1 million or $2 million, was selling her product. And then one day she receives a notice saying that the item was removed because of a complaint for trademarks. And when we looked at the trademark, we saw that she never had a trademark. And we saw that a Chinese seller, a Chinese individual registered her brand as a trademark in the United States. And then when he got the trademark, he removed her item. So that was, we
Those
had to.
story,
It's
unbelievable stories.
it's terrible, and what was even more difficult is that, she had two choices. One would be to buy the trademark from that person, which is, kind of giving up and and surrendering to terror, right? And the
Yeah.
second option was to cancel the trademark. So what we did is we applied for a cancellation of the trademark. We knew that this would take 4 months, and there's no way she's losing sales for 4 months. So after we filed that cancellation, we started speaking with the seller, and after several letters, he transferred it. But this was a terrible case. I mean, it could have ended with payments. So either way, you either pay the lawyers or you pay the guy, but you pay. Since a trademark is
Yeah.
really not expensive, doesn't matter who does it, it's really not expensive. I highly recommend taking care of that.
I agree.
The next topic would be around copyrights. So copyrights, when I speak with a room full of sellers, I always ask how many of you own copyrights, and then maybe one or two raise their hand, and then I ask how many of you took a photo on your iPhone, or and then they all raise their hand. And then I explained that, if you took a photo, you're owner of copyrights. So what people don't know about copyrights is that you do not need any registration to own rights. If I write a letter for you, or for my son's bar mitzvah, tomorrow, if I write something, 2-3 paragraphs, I own the copyrights in that text. It doesn't even matter what type of text it is, as long as it's creative enough and not just dumb basic sentences. So text is protected. Photos, if I take a photo of you on my phone, I own the copyrights, not you. And if I draw something, I don't know, if my 4-year-old draws something, he owns the copyright, even if it's really ugly and you won't understand what it is. What you see here, for example, are there's a scarf with the dog and the owl here. What the common mistake is that sellers are getting samples from their supplier. Here's a paper plate with a tiger, and then they say, great, do you own the rights? The seller asks. The sellers know, the seller knows about IP, so he asks, and then the supplier says, of course, we own the rights, you can use it. And then the seller lists those items, and then they're sold on Walmart, and everything goes well. And then boom, one day the item is removed. What happened? Turns out that this tiger, the person who designed it was the previous client of your supplier, and they own the design. They filed a complaint. It took them between 1 and 2 minutes to file the complaint, and all they needed to do is to show that they have another item that was maybe listed before with the same image, or on the website you can see the image, and then they declare that they own the rights, and then the item will be removed from the catalog. That's very, very sad when you have 500, 1000, 2000 items there, and you can lose a lot of money. What you can do, and it's actually easier than what I said earlier about searching trademarks, hiring a lawyer. In this case, it's very, very simple. Do not copy graphic designs or text or photos of a third party. Okay, always create your own. If you have an item and you need a photo, do not count on anyone. Do not count on your supplier. Do not count on on I don't know, images that you found online. These are always protected. These always belong to someone else. Always take your own photos, write your own text. I can go on for an hour to talk about Chat GPT and if that's infringing or not. These days, in 2023, it's difficult to say that it's infringing. Meaning that if I even take a text of that Michal wrote, and I ask ChatGPT to rephrase that, and then they rephrase something completely new, but based on the same material, it's difficult to say that it's violating the copyrights. The laws will probably change, but right now this is not infringing. It's best, of course, to create your own if you can. But the AI is such a big part of our lives today. I think that if you do that, then the chances that the item will be removed are much lower than if you just copy someone else. Okay, so
Yael, I have two questions. So my first question is about the seller that put the claim to remove somebody design. So
yeah.
is that seller had to have any kind of trademark or brand registry or anything to be eligible to?
No, I can even without the brand portal. I can show you later. You go on, if you Google now, you do Walmart patent claim or Walmart copyright claim, you'll get to a form, and on that form you can see that you can list your item, the link to your product. You can attach whatever you want. You declare, and that's it. Walmart is not as vicious as Amazon. Right now they do check more, in my opinion. And they, Amazon, it's like, let's remove and then ask. With Walmart, it's a little better right now. I mean, who knows with time, as they have more and more complaints, if it will be worse. But the answer to your question is, you don't need anything. You don't need a registration of copyrights. You don't need a registration of the brand portal. You just need to Google IP form, copyright form, and then you file it. You show you have it, you declare, and that's it. 2 minutes later, you removed someone. That's how easy it is. And you, on the other side, you have to understand how easy it is to remove you.
Yeah.
So never ever copy a graphic design. Never. If you want a tiger, okay, do a tiger. Go on Fiverr. I can recommend 5 different designers that will get you another tiger.
So that was my next question. So you go on Fiverr, you get a designer, he's doing all the changes, and then again, now the designer owns this copyright. So what's the process to get a copyright?
No. With these platforms, most of them actually get you a contract that they assign to you the rights in the designs that they created. And if they don't, then you can, speaking of ChatGPT, ask ChatGPT to create a very short contract where the designer assigns the rights to you in those designs. A very, very easy form. So, but like you said, it's true that originally it belongs to the creator. But in most cases, these are transferred. Fiverr takes care of it. I think it's Fiverr or Upwork. One of them definitely takes care of it already. And if you don't, then ChatGPT will get you one.
So still, even if you go and you take a designer and you create your own design, make sure you get copyrights.
Yeah, absolutely. Good point. By the way, a lot of people ask us about images that they buy on Shutterstock or other stock images, and that's a good question, because you buy them, so presumably you can use them. I mean, why you bought the rights, right? But if you read the fine prints, there's actually several types of licenses. So if I bought the rights in this tiger, I have to make sure that the rights that I bought are fit this situation. So it's a right to produce products that bear that design. Okay, because some of the licenses that you get only allow you to publish that tiger on your website, or or I don't know, or use it internally, or using here and there, or publish it one time, not produce it, not having that design being your product. So always read the license. I always tell clients, they're like on the phone, I'm on Shutterstock, and then so there's a few license, which one do I need? And they want me to say the cheapest one, and I always say so take the most expensive one. So that usually that's the case if you want to produce something with a certain image, especially if it's a core part of your product.
All right.
So we talked about trademarks with the search. We talked about copyrights with the images and the graphic designs and the text. And I'm going to go to the third one that most sellers have heard of, and that's the patent. So maybe as an introduction, very quickly, there's two kinds of patents. There's the design patent that covers the shape of the products, like you can see here, okay, the shape of this bottle on the right. And there are utility patents that cover the technology, okay? Most most of you have heard of actually of utility patents. The most I have an idea, let's patent that. These are usually you're talking about the utility patent, which is kind of broad. It doesn't cover a specific design, it covers a specific technology, maybe the lid, the way it's closed or something like that. So that's one patent. The design patent, many people don't know about it, but on Amazon and Walmart, and on most platforms, this is the IP that is enforced the most. The most, of course, after trademarks and copyrights. And with time, what we saw, while in the past nobody had it, these days, if you look at all the complaints that are filed on Walmart and are filed generally, and if you look at the rights of most sellers, many of them have registered patent rights. So one of the most common mistakes is forgetting about patents, and then you launch your product. You have a nice bottle, you start selling it, and then you receive a notification from Walmart that you are infringing a design patent. You come to your attorney, and I tell you, okay, let's see if you're infringing or not. That's the first step. If you're not infringing, we're gonna try and fight it with Walmart and show them that you're not infringing. If you are, then there's two solutions. One would be to try and get a license from the owner of the patent and tell the owner, yes, you're the owner. I'm happy to pay you X dollars for each unit that I sell using your patent. And then you get rid of that inventory. You may want to continue if it makes sense margin wise. And the second solution would be to try and cancel that patent if it hasn't been accepted correctly. So, for example, we have seen many cases where sellers were received a registration for something that actually existed for years. And in that case, what you can do is go to the patent office and try to invalidate that patent by showing that it already existed. And that's what we call a prior art. And that means that, it should not have been registered, because patents are only granted to those who bring something new, as you know. So the solution is either finding a prior art and trying to cancel the patent, or by the way, in many cases, we go to the seller and say, hey, you removed us, you removed our client for violating a patent, but this patent should not have been granted to you because it's been in use for a year. We are going to be canceling your patent unless you retract that complaint and let us sell. And sometimes what happens is that they say, okay, this seller is litigious, let's leave that seller alone, she's crazy, let's reinstate that and let's retract the complaint we had, and then at least the others will be able to remove them. But jokes aside, I mean, many patents that you see should not have been granted, and many patents that that are filed are enforced correctly. I'd say it's about in our law firms, the cases that we see, I think about 60% of them are correct, and they should have been removed, and maybe 40% or something like that would be false alarms, and and we can reinstate that item. The best way to avoid that, the whole story that I said here, the best way to avoid this problem is to conduct a search to make sure that you're not infringing on any patent. Before that, the best way is to, of course, create your own product and design your own product. That's more expensive, and many sellers want to invest in the mold. So it's not necessarily relevant for all of them, but conducting a search would be a good idea. And there are several ways. The best way is, of course, to hire a professional patent attorney. The second best way would be to find someone on Fiverr that will run a search for you. The third one would be to conduct a quick search yourself. I prefer that than nothing. And the quick search, you can do it on Google Patent. So, for example, in that case of this bottle, if I copied the Camelback product here on the right, okay, I know that I'm selling something that is very, very similar to the Camelback. I want to make sure that I'm not violating any rights and they don't own a patent. So I'll go to Google Patent, and then on Google Patent, which is a kind of Google full of patents, I search for Camelback, and then I see a list of all their patents, and then boom, I see that the first or third one here are design patents. You can see it starts with USD here at the end, and then I would look at the design patents, and I see that it's kind of the same as what I wanted to buy. So this product is protected, and I cannot manufacture and sell something that's identical to this. Can I sell something that is similar? It depends how similar. If it's substantially similar, like the courts say in the United States, then no, it would still be infringing. If it's something completely different, you can sell it. If it's something in between, it depends. It depends how many changes you've done. Many sellers think that there's like, if you do 4 changes, you'd be okay. It really depends on which changes, right? You can do 1 change and it would be so dramatic that it's completely, a completely different product. So that's in a nutshell about patent and design patents. Here I focus on design patents. It's the same for utility patents. You can conduct a quick search yourself. It's a little difficult to understand them. So design patents, you have images. You know if you're infringing or not, right? You compare them. With utility patents, I don't know if you saw these, but it's a description of the claims, and then you scratch your head, you try to understand. I'm not a patent attorney. We have a patent attorney in our team. I can tell you that even for me, I've been doing IP for 18 years. It's very difficult to understand if you're violating a patent if you're not a patent attorney. So best way, professional. Second best, someone on Fiverr, Upwork, or one of these. And third best way is to do it yourself. And the worst is not doing anything and just let's try and see what happens. So that's in a nutshell. Michal, any comments on the patents? I'll move on.
I think it's great information. I hope everybody's taking note.
So the last comment that I would make, so that sellers won't forget, is ignoring your own protection. That's a very common mistake. We talked about how not to infringe. Remember that you may own rights. Okay, you may be the owner. You see the shape here on the right. They own design patents. You see that wonderful butterfly, not really, but this can be protected by copyrights because this is a graphic design. So remember, you own the copyrights even without a registration. You can register, but you own it even without a registration. And so if you created something, think twice, consult with an attorney or anyone in the IP space. It's worth it. And I can tell you that down the road, when you want to sell the business, if you have patents, your business is worth X. If you have no patents and no IP, the business is worth less. We see less demand for less innovative businesses. So don't forget to, don't ignore your own protection. If you invented something, it doesn't cost much to protect it, and you'll see the results later. So do it before you manufacture and before you even publish it. So I know we're out of time. So that's it. If you have any questions, of course, feel free to reach out and send us an email. I'm also available on Facebook, LinkedIn, whatever is easier for you.
Wow, Yael, thank you so much. And I know you have some bonus for our
Yes.
our members that gonna get the all access pass. So you want to tell them about your bonus?
Yes. So we have two things. One would be a 10% discount on your trademark, the first trademark. So if you have 20, it doesn't apply to all. And we also provide a guide for how to apply to Walmart's brand portal. So feel free to reach out.
Amazing. Thank you so much. And we'll
Thank
see you
you.
guys in the next session.
Thank you. Thanks for having me.